friends, welcome to the Point. In this session, let's discuss about salient features of Indian Constitution. We know that our Constitution is very unique in nature and its content as well as its spirit. Even though our Constitution is borrowed from various constitutions of the world, our Constitution, it has many salient features. We can differentiate it from Constitution of other countries. Our original Constitution, which was adopted in the year 1949, it has undergone many changes, and on account of several amendments, particularly 7th, 42nd, 44th, 73rd, 74th and 97th amendments. We can say that 42nd Amendment Act, which was undergone in 1976, it is known as mini constitution. Why? Because all the important and large number of changes were made in various parts of this constitution under the 42nd Amendment Act. Now let's discuss about the salient features of our constitution. Lengthiest written constitution. Our constitution is said to be a lengthiest written constitution. What is written constitution? Written constitution means whose amendment procedure is mentioned in the constitution is called as written constitution. An unwritten constitution means whose amendment procedure are not mentioned in the constitution is called as unwritten constitution. The Constitution of India is said to be the lengthiest of all the written constitutions in the world. And British Constitution is the only constitution in the world to have unwritten constitution. There are 4 factors that have contributed to the elephant size of our constitution, and they are geographical factors, historical factors, single constitution for both center and the states, as well as the dominance of legal luminaries of the Constituent Assembly. The Constitution does not contain only the fundamental principles of the governance, but it is also detailed in the administrative provisions. Indian Constitution is drawn from various sources. That means the Constitution of India, it has been borrowed from most of the constitutions in the world, as well as from the Government of India Act 1935. So Dr. B.R. Ambedkar, he proudly said that our Constitution of India, it has been framed after ransacking all the constitutions of the world. The structural part of our Constitution is derived from the Government of India Act 1935, and the philosophical part of our Constitution, that is fundamental rights, directive principles of state policy, they are derived from the American and Irish constitutions. The political part of the Constitution, that is the principle of cabinet government and the relation between the executive and legislature, these are all derived from British Constitution. There are also many other provisions which have been derived from the Constitution of Canada, Australia, Germany, USSR, which is now Russia, France, South Africa, Japan, and so on. Our Constitution is said to be a blend of rigidity and flexibility. Why? Because our Constitution is classified into rigid and flexible. A rigid Constitution is one that requires a special majority for its amendment. For example, American Constitution. And whereas a flexible Constitution, it requires only a simple majority or an ordinary majority to make the laws. For example, British Constitution. Whereas our Constitution India, it is neither rigid nor flexible, but it is a combination of both. Under Article 368, 2 types of amendments can be done. Some provisions can be amended by special majority of the Parliament, that is 2/3 of the members of each house present and voting. And some other provisions, it can be amended by a special majority of the Parliament and with the ratification by half of the total states. And some provisions, it can be amended by simple majority also. And that is why our Constitution is said to be a blend of rigidity and flexibility. Federal system with unitary bias. Constitution of India, it establishes a federal system of government. That means it contains all the usual features of federations like two government, division of powers, written constitution, supremacy of the constitution, rigidity of the constitution, independent judiciary and bicameralism. The Indian constitution, it contains a large number of unitary or which is also called as non-federal system of government like a strong center, single constitution, single citizenship, etc. But the term federation, it is nowhere mentioned in the constitution. And Article 1 says that India as union of states, which means that India is a federation. Even though it is arranged and it has an agreement by the states to be together, and also any state or no state has the right to secede from this federation. So hence our Indian constitution can be described as federal in form but unitary in spirit. Ours is a parliamentary form of government. The Constitution of India, it has opted for British parliamentary system of government. And the parliamentary system, it is also known as Westminster model of government, which is also called as responsible government and cabinet government. The Constitution establishes the parliamentary system not only in the center but also in the states. The features of parliamentary government in India are the presence of nominal and real executives, majority party rule, collective responsibility of the executive to the legislature, and membership of the ministers in the legislature, leadership of the Prime Minister or the Chief Minister, dissolution of lower house, that is Lok Sabha or a legislative assembly, synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of the parliament, it is associated with the British Parliament, and the principle of judicial supremacy, it is associated with the American Supreme Court. Like Indian parliamentary system differs from the British system, the scope of judicial review, power of the Supreme Court in India, it is narrower when compared to US. This is because American Constitution, it provides for due process of law. Due process of law, it is based on the principle that a person cannot be deprived of life or liberty or property without appropriate legal procedures and safeguards. For example, in the United States, the Fifth Amendment prevents the federal government from seizing private property without a prior notice and compensation. The Indian Constitution, it establishes a judicial system that is integrated and as well as independent in nature. The Supreme Court stands at the top of the integrated judicial system in our country. Below the Supreme Court, High Court stands at the state level. And under the High Court, there is a hierarchy of subordinate courts, that is district courts and other lower courts. And among all these courts, Supreme Court is a federal court, that is the highest court of appeal. Supreme Court is said to be a guarantor of the fundamental rights of the citizens and the guardian of the Constitution. Fundamental rights. Part 3 of our Indian Constitution, it guarantees 6 fundamental rights to all the citizens. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. So about all the fundamental rights, we'll be learning in Fundamental Rights chapter in the upcoming sessions. Directive Principles of State Policy. And according to Dr. B.R. Ambedkar, the Directive Principles of State Policy is said to be a novel feature of the Indian Constitution. And these are enumerated in Part 4 of the Indian Constitution. And Directive Principles of State Policy, it can be classified into 3 broad categories like socialistic, Gandhian, and liberal intellectual. The Directive Principles, they are meant for promoting the ideal of social as well as the economic democracy, and they seek to establish a welfare state in India. Fundamental duties. The original constitution does not provide any fundamental duties for the citizens. And this fundamental duties, it was added in the constitution during an internal emergency which occurred during 1975 to 77. And this was inserted by 42nd Constitutional Amendment Act 1976 on the recommendation of Swaran Singh Committee. We can say that the fundamental duties, they serve as a reminder to the citizens that while enjoying their rights, they also have to perform their duties they owe to their country, their society, and as well as their fellow citizens. A secular state. The Constitution of India, it stands for a secular state. Why? Because our country, it does not hold any particular religion as the official religion of the Indian state, and that's why our country India is said to be a secular state. The term secular, it was added to the preamble of Indian Constitution by the 42nd Constitutional Amendment Act 1976. Thus the preamble secures to all the citizens of India liberty of belief, faith and worship. Indian Constitution, it adopts universal adult franchise as a basis of election to the Lok Sabha and the State Legislative Assembly. Every citizen who is not less than 18 years, that is, the person should be more than 18 years of age, and that person has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth and so on. Initially, the voting age was 21 years during 1989, but by the 61st Constitutional Amendment Act, this was changed and the voting age was reduced to 18 from 21. The Indian Constitution, it provides for a single citizenship for a citizen. Even though our Constitution, it is federal in nature and it envisages dual polity, that is center and the state, and it provides only for a single citizenship, that is Indian citizenship. When you take the countries like USA, the person is not only a citizen of USA, but he is also a citizen of that particular state. That means the person who belongs to USA has dual citizenship. One is country citizenship and other is the state citizenship. Our Indian Constitution provides independent bodies apart from legislative, executive and judicial organs. And these independent bodies, they are envisaged by the Constitution as a bulwarks of the democratic system of government of India. And these are the Election Commission. Election Commission, it is an independent body which ensures free and fair elections to the Parliament and also to the state legislature, the office of the President of India and the office of Vice President of India. Comptroller and Auditor General of India. This is also an independent body which audits the accounts of state and central governments. Union Public Service Commission. This independent body, it will conduct examination for the recruitment of all India services and high central services. This commission, it also advises the President on disciplinary matters. Every state has State Public Service Commission to conduct examinations for the recruitment to state services and to advise the governor on disciplinary matters. Emergency provisions. Our Constitution envisages three types of emergencies. They are national emergency, state emergency and financial emergency. National emergency is imposed on the ground of war or external aggression or armed rebellion. State emergency. This emergency is imposed on the ground of failure of constitutional machinery in the states. Financial emergency is imposed of the threat to financial stability of a country. During the period of emergency, the central government becomes the powerful body, and all the states go under the control of center. And at that time, the federal structure of our country becomes a unitary one, without a formal amendment of the constitution. This kind of transformation of a political system from federal to unitary, it is a unique feature of our Indian constitution. Three-tier government. Originally, Indian constitution, it provides for dual polity and it contained provisions with regard to the organization and powers of the center. And later, in the 73rd and 74th Constitutional Amendment Act 1992, it have added a third tier of government called local government. And initially we had only central government and state government. Under local government, two types of governments exist, like panchayats and municipalities. Cooperative societies. The 97th Constitutional Amendment Act 2011, it gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the constitution. One is, it made the right to form cooperative societies as a fundamental right under Article 19. And it included a new directive principle for state policy on the promotion of cooperative societies under Article 43B. And it also added a new part 9B in the Constitution, which is entitled as the Cooperative Societies under Article 243ZH to 243ZT. Apart from all the 17 salient features of our Constitution, there is some criticism of the Constitution also. The Constitution of India, as it is framed and adopted by the Constituent Assembly of India, it has been criticized on some of the grounds, like as it is a borrowed constitution, it is a carbon copy of 1935 Act, it is an un-Indian or anti-Indian, or it is an un-Gandhian constitution, and it is also has an elephantine size in nature, and it is a paradise of lawyers. These are all the criticism that our constitution faces. Okay, see you in the next session with some other interesting topic. Thank you.